which is Sharon Smith versus Lowe's Home Centers, LLC in Sedgwick, CMS. Case number 202156. I believe Mr. McKnight, your counsel for the appellant, you may proceed when you're ready.
May it please the court. I'm Daniel McKnight. I represent Sharon Smith, the appellant. I would ask to reserve 5 minutes.
So noted.
I think the Florida Supreme Court said it very well in Boca Burger versus Forum that allowing sanctions against appellees or their counsel for defending indefensible orders requires the quintessentially professional act of admitting defeat when there is no chance of victory, or when victory will have been obtained at the price of integrity and truth. That's what we're dealing with here. When the trial court laughs at your opposition, states that he will not consider their position and that what he's willing to consider is something else, you know that any victory can only come at the price of integrity and truth. When the trial court says that Mr. McKnight, I think, needs to file a new position, but if we go forward today, we can wrap everything up. We'll take the test. Or when he says, you know, this may be coming back. Well, I'm not sure what happens, because to the extent that he'll what? Or when he says, if I'm wrong, I'll get an opinion from the appellate court telling me I misunderstood. Or that's not in the entire quote. It says, if I'm wrong, then you know at some point a year from now, I'll get an order. He said in those words,
let me ask you a couple of questions, if I may. I want to make sure I understand your client's position in this appeal. It's your client's position that the pay and investigate provisions were not timely invoked, correct?
Yes, they elected to, they had 3 options and they chose to accept. They did not choose to deny or to pay and investigate initially.
If, and I know you dispute this, but if they were in fact timely invoked, you would agree, would you not, that that would weaken your client's position?
It would, there would still potentially be some dispute as to it would weaken the position.
And here's what I'm getting at, Mr. McKnight. I don't know, do you have a copy of 44020 in front of you?
I can, it'll take just 1 second.
And in particular, subsection 4, which I know you're both well aware of.
Yes, Your Honor.
The 3rd sentence of that subparagraph reads, upon commencement of payment as required under subdivision 2, and subdivision 2A starts off by an installment of compensation for total disability, et cetera. Sub B deals with medical, dental, pharmacy, and hospital bills. And so back to the provision I was reading, upon commencement of payment as required under subsection 2 or section 4401928, the carrier shall provide written notice to the employee that it is elected to pay the claim pending further investigation, and that it will advise the employee of claim acceptance or denial within 120 days. As I read that sentence, Mr. McKnight, it sounds like the initiator of the written notice is the commencement of payment. And as I understand this record, payment of the first bill was made on October 8th, and that was for Dr. No's first bill. So if payment is the initiator, the commencement of payment was the initiator of the need to give written notice, it sounds like the EC complied with the requirements of the statute, in particular the pay and investigate provisions. Help me understand why I'm reading that incorrectly.
My understanding of that is that it applies a different rule when the initial provision of benefits is in the nature of money benefits to the claimant as opposed to medical benefits. In that case,
and thank you. That's helpful to have your explanation. What it looks like it says under subsection 2, and that has to be the same statutory section. 2B says the carrier must pay, disallow, or deny all medical, dental, pharmacy, and hospital bills submitted to the carrier in accordance with the department rule no later than 45 days after the carrier's receipt. Apparently, the EC did that here. So why, again, would that not make the pay and investigate timely? If in fact I'm seeing this rightly, that 2B was the provision that they paid Dr. No's first bill under.
As far as the claimant's concerned, it doesn't matter if Dr. No's ever paid. She requested medical treatment. The employer carrier can find a way to make that happen, and the benefit to the claimant was already performed. She received the evaluation on the 13th. She received the treatment on the 13th. And so whether they choose to pay their doctor or not is really of no concern to the claimant.
Well, and thank you for that, Mr. McKnight. I guess my point's a bigger point, that if again, that third sentence of subsection 4 says the initiator of the need for the written notice is the commencement of payment, and the payment here was on October 8th. They actually gave written notice ahead of the payment. So that would, as I read that sentence, make their decision to pay and investigate timely. But
I don't think
that aside, your position is that it was not timely, correct?
that is the position. As to that issue, that could create a problem is if the carrier never paid. If, for example, they used an in-house doctor who they never had to initiate payment to, who saw the claimant, treated them, and there was no payment at any point, then you could never have an untimely notice. They could just never accept it. The claimant would be stuck in a position where she's going to the doctor.
What do you do in the situation where, I mean, so your argument is that the notice has to be provided before treatment. So what if it's the treatment is for a life-threatening accident? So how would the burden possibly be met in those circumstances?
I think in an emergency situation, the emergency care would occur without the injury ever being reported to the employer, without there ever being a decision to accept or provide benefits. Someone would just call 911, and that, I think, is a very different situation than when a claimant calls to say, hey, I have an injury, please take care of it. And the claimant comes in and they fill out a report and they make a conscious decision that they will treat this, they will send her to the doctor. When a claimant's hurt, they don't report it to the JCC, and you don't file a petition. It starts with the employer, and the employer makes the determination of compensability. That's actually the definition of the word compensable. And 440.
Mr. McKnight, what would you have had them to have done here? Obviously, your client called her supervisor and said she had been injured related to her work. And then he starts the process of sending her to Dr. No. She ends up going to Dr. No. I mean, you certainly don't have a problem with that part of this, the fact that he referred her to Dr. No to seek treatment. What more did the carrier need to do, though, in that situation?
Well, assuming that they didn't intend to accept the condition, that they were sending her to a doctor without the intent of accepting, they should have told her that. They should have given her some piece of paper saying, hey, we're not accepting this. We're protecting our rights, and we may deny it with 120 days, at which point the claimant would have considered, well, maybe I should also protect my rights if that's what they're doing.
Well, and perhaps back to Judge Ray's question and taking it to its logical end, that almost requires an immediate notice, does it not? In a situation where you have someone who is seeking care the same day, like your client in this case?
It's very well possible that a claimant could ask for workers' compensation benefits, could report an injury immediately after it occurs. And I don't think it's too much to ask that the employer would say, we're not really sure what's wrong with you, what exactly the injuries are. We're going to send you to our doctor to figure out what's wrong, and we'll take care of whatever our doctor says we caused.
Is there any evidence in this record of any colloquy discussion between her supervisor and the claimant here as to what the supervisor actually said to her?
The judge found that she reported the tear to the doctor, and there's no cross appeal challenging that finding of fact. It's discussed, I believe, in the claimant's deposition, where she indicates how she initially got the MRI and that she told the carrier.
And my question is a little bit more specific. I'm talking about the supervisor actually talked to your client, correct?
Yes.
I'm just trying to understand what was involved in that discussion. Was there anything about, we're going to take care of this, no need to worry, we're accepting responsibility for this, anything of that nature?
The employer carrier objected to all of that coming in, and the trial court ruled in the employer carrier's favor. They kept out the report that was filled out and completed. They really didn't want that to be in the record, and so it's not in the record on appeal.
Thank you.
Counsel, you have about 4 minutes remaining. I know you wanted to reserve some rebuttal time. Would you like to make any more argument before I turn it over to the appellee?
We will reserve the remainder.
Okay, thank you. Ms. Hyde.
Thank you, Chief Judge Ray. May it please the court, my name is Tracy Hyde here on behalf of Lowe's and their servicing agent Sedgwick. The whole key in this case is the lack of medical testimony from anyone on the claimant side to relate her condition that she claimed was related to work. Mr. McKnight discusses the act of sending her to a doctor was immediate acceptance of her condition. Essentially, whatever she wanted to claim was related to work, they, by sending her to the doctor, said, we're good. The employer is not in a position to make a medical determination of relationship of a condition to a work injury. So they send her to a doctor and then send the 120-day letter out later. There is not a single case or anything in the statute that would support that the act of sending a claimed injured worker to a medical provider constitutes acceptance of whatever it is that she has. And so there's no medical evidence of an injury as related to work. And in appellant's initial brief, she very clearly states at page 18 that it's not claimant's burden to prove occupational causation. I've been practicing for 26 years. It has always been the burden of the claimant to establish occupational causation. By virtue of her simply stating to her employer, using an unauthorized physician, he told me this, therefore it must be related to work, nothing came after that. Mr. McKnight stated—
You just used the term unauthorized physician, or you're not
well,
talking about
personal
No.
physician, a physician that was never authorized to provide care, in this case, her podiatrist.
Okay, thank you for clarifying that. Please proceed.
So the claimant trying to testify as to what her podiatrist told her was correctly inadmissible because her podiatrist was not an authorized physician and therefore not authorized to give opinion testimony as to causation. His records are in for fact purposes, but that's it. And so the whole thrust of the case is that the claimant's position is that because I told my employer, my podiatrist told me I had a tear, it doesn't make it related to work. There's no medical evidence that her condition was related to work. And in Mr. McKnight's closing argument at trial, he says that their knowledge demonstrates their acceptance. That's at the trial transcript on page 84. And so it appears the argument is that I told you what I had, you sent me to a doctor, therefore I'm good. I don't have to prove causation. I don't have to present any medical testimony that the condition I'm complaining of is related to my employment. And that's just not, I mean, 440.091 says not only is it her burden to show a relationship between the condition and work, it goes on to say that in cases which involve repetitive exposure, which it appears that that's what this was about, both causation and sufficient exposure to support causation must be proven by clear and convincing evidence. There's nothing in the record to support that her condition was related to work.
Counsel, for purposes of the pay and investigate provision,
Yes, sir.
does it make any difference in this case that the EC sent the claimant to see Dr. Galloway more than 120 days after the provision in question?
That's correct.
Does it make a provision in terms of the analysis?
No, not really, sir, because as the judge found, that once the employer carrier sent her to Dr. Galloway, which was obviously well after 120 days of the initial provision of benefits, that they waived the argument that she had an injury at work, but there was no, so they couldn't argue 120 days. But the point is that the claimant was sent to Dr. Galloway to assess and treat any compensable conditions. When she went to Dr. No in September, he diagnosed her with a right foot pain and right ankle swelling, and that was it. That was all. That was the extent of his diagnosis. He testified in deposition that he could not define the cause of her condition. He admitted that the MRI done by the personal podiatrist showed a tear, but he couldn't opine as to causation. And he even told Mr. McKnight that when they had a conference a couple of months before the deposition. He said, "I can't tell you what caused it. That's why I referred her to an orthopedist." And Dr. Galloway said in his note that her condition was a pre-existing interstitial tear and that she suffered a flare at work of right foot sprain strain and therefore resolved MMI 0% full duty.
So that flare exacerbation was related to the job as opined by Dr. Galloway?
Yes, a right foot sprain strain.
I do have a question about the record, and there have been strong words on both sides, both below and on appeal,
Yes,
about the merits of defenses and the merits of claims. There was a pretrial stipulation here where the EC said that the claimant had a sprain, and in essence, the EC was accepting the sprain strain, but that was ahead of Dr. Galloway actually seeing the claimant. And as I see the record, that was the first time those terms were ever used. Should that give us pause here? That there was a stipulation made by the EC as to something that had never been diagnosed until Dr. Galloway actually saw her 3 days later?
Well, I don't think the word sprain strain might not have been used until it was on the pretrial, but that was essentially what Dr. No put in his notes, that she had right foot pain and right ankle swelling, which is essentially equivalent to a sprain strain. I understand your question, Your Honor, and it's routine for employers carriers when we do fill out pretrials that we would put what the accepted condition was as compensable. I think it's a sprain strain is a very common term in workers' comp, and I don't know that it should give you pause. I mean, I don't personally know Dr. Galloway, but I assume he frequently sees workers' compensation folks that have sprain strains in it. I don't think it should give you pause.
And I'm not in any way saying that was not within his purview to make that diagnosis. Certainly as an orthopedic surgeon, he has every right and every capacity to make that diagnosis / give that opinion. I guess my only question was how it was that pops up into a pretrial stipulation where those two terms had not been used, as I saw on the record, until then, until 3 days later when Dr. Galloway actually saw the claimant. But what you're saying, so I make sure I understand, if I can try to say it in a sentence, is that in essence, that's what Dr. No said, even though he didn't actually use those terms.
Yes, sir.
So is it also your argument here today that Dr. No related those to the accident, or he did not, and he deferred to Dr. Galloway?
He deferred to Dr. Galloway. I mean, based on her complaints, and his examination of her, he testified, and it's also in his records, that her diagnoses were right foot pain and right ankle swelling from her complaints and his examination of her. But as far as the tear, the tendon tear that claimant claims is compensable, he said that he could not diagnose that. He says, yes, it's on the MRI. So, that's what the MRI says, but I can't diagnose that. And so he deferred and everything to the orthopedist. And in fact, he referred her to an orthopedist at the second visit on September 23rd.
Counsel, is there anything in this record that the EEC accepted and provided benefits for any condition other than the right foot strain?
No, sir. There's nothing in the record to accept claimant's belief that by the employer sending her to Dr. No, that they accepted whatever she said, her doctor said was wrong with her. So no, there's nothing in the record to show that we ever provided treatment for it. And when claimant filed her brief, the refrain was the tear and the plantar fasciitis were compensable by operation of law. But all the cases that discuss authorization or compensability by operation of law deal with the 120-day rule. And Mr. McKnight clearly stated at the trial that this was not a 120-day case. He said, I want to make it very clear, this is not a 120-day case. So if it was, and there had been evidence that treatment for those particular conditions had been provided, and then 120 days later, and 120 days passed, then she'd be right. But this is not a 120-day case. No treatment for those conditions was ever provided. There's no case that says sending a worker claiming an injury to a walk-in clinic equates to binding acceptance of whatever conditions a claimant might claim are related to work. 440-091 says there has to be medical testimony to support that the condition for which her unauthorized or personal podiatrist diagnosed were in fact related to her work activity, and there was never any medical testimony of that or medical evidence of that. And again, if she was trying to show repetitive trauma, there had to be clear and convincing evidence, and there wasn't any of that either. And I'm just beating a dead horse, so I don't have anything else to say.
Are there any additional questions? All right, hearing none. Thank you, Ms. Hyde. I'll turn it back to Mr. McKnight.
I'd like to briefly mention, opposing counsel said she's been doing this 20 years. She's never heard of this. We cite to cases. This court has previously said that providing benefits is obviously acceptance. They use that word. And in the Sanchez case, or here in with this doctor, the orthopedist they sent us to, why can't they say that the benefit was provided because the doctor treated the tear? Well, because if the doctor treated the tear, then it's compensable. That's an acceptance. And so they want to say Galloway didn't treat the tear because the underlying is, if they did, then it would have been compensable. As opposing counsel agreed, as we've stated, I think I told the trial court, I want to be very clear, this is not a 120-day rule case. And we do both agree this is not a 120-day rule case. There are three options: acceptance, denial, or the 120-day pay and investigate. It's not the 120-day, it's not a denial, it's an acceptance. The definition of compensable says a determination by a carrier or a judge of compensation claims. So no matter what the judge of compensation claims thinks, if it was determined by the carrier, it's compensable. That's literally the definition of the word. It's a self-executing system. We don't have to go to the comp judge to prove compensability. If we go to the carrier and we go to the employer and they say, we have this, and they go and they provide the acceptance, they treat the condition, there's really no room for honest dispute that providing treatment in the absence of a reservation of rights is acceptance. That's what the cases we cite to say. Let's just see. In terms of sanctions, I'd just like to briefly address the question of the amount. I think the trial court mentioned, the JCC said, if he gets reversed, it'll come back a year later. And during that year, the claimant's been walking around with a torn tendon in her foot in excruciating pain. The frivolous arguments of opposing counsel are the cause of that pain and suffering. And I think that we need, in order to appropriately remedy that, to measure the sanction by the damage that the conduct has caused. If the attorney's fees are less than the amount of the pain and suffering, well, we'll keep coming back to this problem. If you can inflict more pain than the remedy is, then it's a viable ongoing strategy to continue this sort of frivolous appellate litigation. We'll rest.
Okay, thank you. Thank you to both counsel for your arguments this afternoon. The court is now adjourned. Have a good afternoon.